All righty. Welcome to everyone. Let's all please stand for the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right. The purpose of this meeting today, and I'm going to call this to order, the Perry County Election Board members here, Lynn Inman, Republican Party Representative, Mary Kay Elder, the Democratic Party Representative, and Rachel Rourke, the Clerk of the Perry County Circuit Court. The purpose of this hearing is to review the complaint of Bradley James D. Hart and Sherry Flynn regarding IC 3-14-3-21-5. I'll have Mary Kay read that IC code.
A person who knowingly or intentionally intimidates, threatens, or coerces an individual for, number one, voting or attempting to vote, number two, urging or aiding another individual to vote or attempt to vote, or number three, exercising any power or duty under this title concerning registration or voting, commits voter intimidation, a level 6 felony.
According to IC code 36531, if a county election board according to the IC code 36531, that is our purpose here today. I would like for Mary Kay to read that.
If a county election board determines that there is substantial reason to believe an election law violation has occurred, it shall expeditiously make an investigation. If in the judgment of the board, after affording due notice and an opportunity for a hearing, a person has engaged or is about to engage in an act or practice that constitutes or will constitute a violation of a provision of this title or of a rule or order issued under this title, the board shall take the action it considers appropriate under the circumstances, including referring the matter to the Attorney General or the appropriate prosecuting attorney.
So what we are doing here today, we are investigating a complaint to determine if there was a substantial reason to believe a violation has occurred. Any person planning on speaking to the Perry County Election Board today, please stand and follow the direction of the Perry County Clerk, Rachel Rourke, as she administers the oaths.
Okay, at this point, I'd like to make sure that we do the administration of the oath. Any person planning on speaking or testifying today must stand, and please come forward if you don't mind, and follow this oath issue.
No, he should be there.
Yes, if you don't mind, sorry.
I just sent there to
Okay.
text.
Good morning. Please raise your right hand and say "I do" after recitation of the oath. Do you solemnly swear or affirm under the penalties of perjury that the testimony that you will give at today's County Election Board hearing is the truth, the whole truth, and nothing but the truth? If so, say "I do."
I do.
Okay. So here, just to sign that. Thank you. Thank you, ladies.
He was supposed to be here. All right, the IC codes have been read, and I would like to give a definition to some of the words there so we understand what it is that we are looking for. To intimidate is to frighten overall, especially in order to make someone do what one wants. To threaten is to state one's intention to take hostile action against someone in retribution for something done or not done. To coerce is to persuade an unwilling person to do something by using force or threats. To compel by force, intimidation, or authority, especially without regard for individual desire or volition. Now, I'll make a motion that these following guidelines be used for today's hearing. The hearing will begin by recognizing that unless there is an objection, all documents provided to the Perry County Election Board will be entered into the record of this meeting. Allie Bartlett, Sherry Flynn's authorized representative, and Rachel Rourke, clerk, will be reading Bradley DeHart's complaint, and each will present their case for no more than 15 minutes unless the election board votes to allow additional time to the presenter. All other speakers will be given 5 minutes to make their presentation. The election board may ask questions during the presentations, and it will not be counted against the presenter's time. The clerk will signal when the presenter's time is up. Following the presentation, the representative of Sherry Flynn may present a rebuttal for no more than 2 minutes. The only speakers today will be the witnesses to the events on May 7th, 2024 at the depot. No public comments will be made. Do I have a second to the motion?
I'll second.
All in favor, say aye.
Aye.
Okay. At this time, I'm going to ask Rachel Rourke to please read the complaint by James Bradley DeHart.
To the Perry County Election Board, please, let me start my timer. Please allow this correspondence to serve as my official notice to file a formal complaint against a poll and/or election worker, Sherry Flynn, specific to her actions, of which I believe constitute voter intimidation under IC Code 314.321.5. I further believe that Ms. Flynn violated my rights under the Indiana Voters Bill of Rights specific to the section that pertains to primary elections. In addition to the aforementioned violations I have cited, I feel that Ms. Flynn targeted and discriminated against me personally at my polling location due to not only my sexual orientation, but my relationship with a high-profile elected official who is of the opposite party of her. Ms. Flynn aggressively initiated a challenge affidavit upon my attempt to vote in the primary election. However, Ms. Flynn did not state or otherwise provide factual evidence to support her reasoning for issuing the challenge when she demanded that I complete and sign the form. Due to the intimidation, aggression, and disruption that resulted from Ms. Flynn's hostile efforts to challenge my vote, the police were contacted and a 911 CAD report was completed. Witnesses of the events that transpired include Mary Hackle, Tootie Parker, and 2 other gentlemen who were there as poll election workers, of which I never learned their names. My partner, Chris Kale, who was also present and witnessed Ms. Flynn's actions. In addition, multiple voters were present for partial moments of the event. The entirety of the events described in detail below took place on May 7th, 2024 at approximately 9 a.m. at the Tell City Depot located at 333 7th Street in Tell City, Indiana. Upon walking into the building, Chris and I walked up to the table where the election workers were seated. Chris checked in first, and then I proceeded to check in with a gentleman who was very nice to me. He asked to see my ID, confirmed my address and name, and then turned a tablet screen to face me to select Democrat or Republican for the primary I wanted to vote in. I selected a Republican ballot for several local reasons and for the state races that I had interest in as well. Once I made my selection, a ticket was automatically printed and handed to me. Unknowingly, a poll watcher, Sherry Flynn, was standing directly behind me, not more than 3 or 4 feet. She asked for my ticket without explaining why she needed it, and then went about 20 to 30 feet across the room to a table where a poll judge or supervisor, I assume, was seated. I watched her pull out a 2-sided form and began writing on it. For several minutes, I stood in the middle of the room waiting while no one offered any information or explanation. It wasn't until I asked what was going on that she turned back and responded by stating, "I'm filing a challenge against your vote." When she stated this, I was confused as I did not know what that meant, and both my partner Chris and I asked at the same time why my vote was being challenged. Ms. Flynn proceeded to approach me, walking toward me in an aggressive manner with the challenge form in hand. She was flipping the form front to back in my face to seemingly show me, and then pointed to where I needed to sign the back of it. Ms. Flynn was not clear in the minimal information she provided about the form or the reason for it. I stated to Ms. Flynn that I did not understand the information or the form, and she proceeded to tell me that I could not vote unless I signed that form. I told Ms. Flynn I was not going to sign the form because I did not understand it, and I specifically told her that. I did not feel safe in her presence due to her intimidating, aggressive demeanor and hostility she was expressing toward me. Ms. Flynn aggressively verbalized very loudly that she was challenging my vote due to me not being a member of the Republican Party. She proceeded to state to everyone in the room that if I cast a vote without signing the form, then it was considered election fraud, and then stated that if my vote was counted, the entire election would have to be redone. Ms. Flynn proceeded to loudly and aggressively state for everyone in the room to hear that I was not a member of the Republican Party. My partner Chris had asked the supervisor if it would be possible to cast a provisional ballot. Before the supervisor could answer, Ms. Flynn interjected, holding up the challenge form, and stated that at the top it clearly reads that a provisional ballot cannot be cast. The supervising judge of the polling location, who was wearing a blue polo shirt, and Ms. Flynn exchanged words while I stood there waiting for an answer of any kind. My partner Chris was standing at the entrance of the building, waiting to learn what we needed to do. Both Ms. Flynn and the supervisor gentleman were both exchanging words while using their cell phones to seemingly call or text someone that could clarify the situation. After approximately 7 or 8 additional minutes had passed, the referenced supervisor who had made a phone call stated that he had spoken with the county election board and that I would be able to vote and proceed toward the voting booth. I verbally confirmed with the supervisor and all the present election workers that it was okay for me to proceed to vote without signing any documents. All election workers who were present verbally agreed that it was allowed. As I proceeded to cast my votes, Ms. Flynn was loudly claiming election fraud and misconduct in the presence of other voters and election workers, and continued to verbalize her reasoning why I should not be voting, loudly enough for everyone to hear. Ms. Flynn further targeted my partner, who was waiting at the door entrance of the building due to his concern for my safety as a result of Ms. Flynn's unpredictable and intimidating behavior toward me. Ms. Flynn proceeded to tell my partner that he could not remain in the building, at which time I told Ms. Flynn that I wanted him to remain as I did not feel safe in her presence without him as a witness. The other election workers allowed Chris to remain due to the volatile events occurring, and Ms. Flynn loudly yelled, "If he," referencing my partner Chris, "is allowed to stay after voting, then I am going to have my husband stay here all day long when he comes to vote later." My partner Chris did exit the room at the time I was able to begin casting my vote. Ms. Flynn caused such a disturbance and distraction as I was casting my votes. I paused from voting to turn around and tell her to be quiet while I am voting, because she literally created an intimidating environment where I could not concentrate on what I was doing or the people I was voting for. Ms. Flynn continued to cause a verbal disturbance until the election worker wearing the blue polo shirt intervened in her attempt to interrupt voting, at which time Ms. Flynn left the room. Chris Kell and I left the building and returned to our vehicle after completing the voting process, and immediately contacted the Perry County Clerk's office to inform them of the situation, of which they were already made aware of by the supervising election worker. We were informed that I did not have to return to sign the form after it was determined that Ms. Flynn was not authorized to challenge my vote based on the fact that she resides in Precinct 2 and I reside in Precinct 1. And a challenger must reside in the same precinct to initiate the challenge, per the Perry County Election Board. At the same time of learning that I was not required to sign the form, I had also been informed that due to disturbance and interference that Ms. Flynn caused at the precinct, the county clerk and election board had contacted the police dispatch to send an officer to the location for a disturbance call and verbal altercation. I have provided a copy of that 911 CAD report that documents that Ms. Flynn was attempting to interfere with me and was hostile and intimidating throughout the process. I am in disbelief of the events that took place and feel personally victimized by the actions of Ms. Flynn. I was publicly embarrassed, harassed, and intimidated while trying to exercise my vote in an Indiana primary election. I am a transplant resident from Kentucky, where I was born and raised, and have only ever participated in one other Indiana election, which was last year for the city of Tell City in the general election. The more disturbing aspect of today is that I have learned that as of this email, there have been 0 challenge votes for this primary, aside from the attempted challenge placed on my vote, which further indicates targeting and discriminatory practices due to my sexual orientation, along with my affiliation and relationship with a high-profile Democratic elected official. To further support my claims of election interference and voter intimidation inflicted by Sherry Flynn, please see the screenshot in this document where Ms. Flynn can be seen commenting on a post stating, because even when Democrats infiltrated our primary, we still win. Thank you for voting. Her comment was made on another person's page in reference to a post made by another individual congratulating Randy Cole for winning, and only further provides evidence that Ms. Flynn was not an objective poll/election worker who supports or believes in the integrity of the election or voting process, clearly identified by her words when the Democrats infiltrated our primary. As a local governing authority of elections and the process involved, I respectfully request all members of the Perry County Election Board to review my report, investigate the details I have provided, and take significant action to reprimand Ms. Flynn to the fullest extent of your powers. If you agree that your investigation concurs with my report. If you concur with my report, I further ask for this board to take immediate action to place a permanent ban on Ms. Flynn from ever participating in or having any working capacity in regard to Perry County elections governed by this board. I further respectfully request that this board, at your discretion and authority, alert and notify all state and federal election boards and commissions as deemed appropriate by your board of this incident, including the Indiana Secretary of State's office, along with the United States Department of Justice and Voters' Rights Division, or Voters' Rights Civil Rights Division, and report and provide them with this report and any and all details they may request, as I intend to do as well. Throughout the duration of my residency in Perry County, I have never questioned my love or passion for this community until May 7th, 2024. I have never felt intimidated or unsafe in a community building the way I felt unsafe on May 7th, 2024 at the Tell City Depot. Ms. Flynn targeted only me for very obvious personal reasons and her assumption that she knew my intent to vote in the Republican primary. My intent has never and would never be to infiltrate an election, as Ms. Flynn referenced. My intent on May 7th, 2024 was to cast a vote in a primary where I supported multiple candidates from the Republican Party. Ms. Flynn further failed to inquire about my personal involvement and history with the Republican Party because she was seemingly distracted by labeling me and intimidating me during the process of trying to vote. What Ms. Flynn remains unaware of to this day due to her own overcrowding prejudices is that I have not only personally supported many Republican candidates locally, statewide, and beyond. In addition to Democrats, I have further personally provided financial contributions to all parties as well, and further assisted multiple candidates, Republican and Democrats, in their campaigns in Kentucky. Ms. Flynn made and used a very ill-informed and prejudiced assumption against me on May 7th, 2024, and used voter intimidation tactics to hinder my constitutional right to vote as an American. It is my sincere hope that the Perry County Election Board, the Secretary of State, and the United States Department of Justice understand the severity of this incident and the precedents it will set, along with the ramifications it will have if not addressed to the fullest extent. Thank you for your time. James Bradley DeHart.
Okay. I know. Okay, at this time, we're going to call for Sherry Flynn's authorized representative, Ally Bartlett. Will you please step forward? Yes, you can. The microphone's there, right there. It'll pick you up.
Okay, great.
You just tell me when you're ready. Go for it.
Okay.
Yeah.
Good morning, Madam Chair and members of the board. My name is Ally Bartlett, and I am here today on behalf of Sherry Flynn as a member of and as appointed to serve as a poll judge by the Perry County Republican Party. Before I dive in, I'd like to acknowledge something that I think is important to keep in mind whenever we discuss matters of politics, governments, elections, and anything else that has such broad impacts on our daily lives. We all know that matters of this nature are emotional. We're talking about a process that goes to the core of our beliefs and outcomes that can change the course of our communities. However, because these matters are so important, it's critical that we set emotions aside and examine laws and facts as they are, not how we wish they were, not how we think they should be. Indiana Code 3-6-5-14A1 states that a county election board shall administer elections within a county and uphold the election laws of the state of Indiana. It does not state that a county election board shall act as a court of law, or worse, a court of public opinion. I think we all agree at this point that the actions taken on May 21st at the meeting are moot at this point and will be disregarded for purposes of this proceeding moving forward, and I hope we can all uphold that understanding. Because nowhere in Title III is the board granted the authority to ban a poll worker for life. In fact, state statute specifically grants authority under Indiana Code 3-6-6-9 to county chairs of the major political parties to nominate individuals who meet all statutory requirements to serve in such roles, and states that the board shall appoint such nominated individuals so long as they are otherwise eligible under the statute to serve as precinct election officers. It does not grant the board authority to ban or otherwise deem such individuals ineligible to hold such offices. And the reason that that authority is granted to county chairs, especially in primary elections, is because primary elections are partisan. The board may, in its discretion, elect to refer any matter it deems to be a violation of Title III to the Attorney General or the proper prosecuting attorney. At hand here today is a question regarding whether a poll judge, Ms. Flynn, may have committed quote-unquote voter intimidation as defined in Indiana Code 3-14-3-21.5. However, first let me note that the board is to view this matter through the lens of whether it believes there was a violation of an election law under Title III, as is its statutory duty. This is not a court of law. If the board determines that it believes there was a violation, it may refer the matter to the county prosecutor, who will or will not, in their discretion, take up the matter of a criminal offense. In order to get to that determination, I think it's important that we get a few things straight first and foremost. It is not a violation of Indiana's election laws, much less a criminal offense of voter intimidation, to issue a challenge on the basis of party affiliation. The authority to issue this type of challenge. Indiana Code 3-5-4.5 covers standards for challenges to voters. It applies to, quote, a challenge to a voter made by a precinct election officer, which includes a judge. Indiana Code 3-5-4.5-3 specifically addresses challenges on the basis of party affiliation and specifically exempts primary elections from that sort of prohibition. Indiana Code 3-10-1 covers primary elections generally. Indiana Code 3-10-1-6 states that a voter may vote at a primary election if the voter at the last general election voted for a majority of the regular nominees of the party holding the primary, or if they did not vote at the last general election, they intend to vote at the next general election for a majority of the regular nominees of the party holding the primary. Basically, if you're a member of that party or intend to become a member of that party. Essentially, you're eligible to vote in a party's primary if you're a member of the party or if you intend to become a member of the party under state statute. Indiana Code 3-10-1-9 states that a voter in a precinct may challenge a voter or person who offers to vote at a primary election. The challenged person, in this case, Mr. DeHart, may not vote, that's a quote from Indiana state statute, unless the challenged person is a registered voter and completes an affidavit if they are challenged. In addition, State Form 42130, aka the PRE 6 form, also states that a challenged person, quote, may not vote without completing the affidavit. Nowhere in the statute nor the form is there a requirement that the challenge be explained or otherwise justified to the voter in question. Again, keep in mind that we are viewing this through the lens of what the law is and not what we want it to be. Indiana Code 3-10-1-10 specifically addresses persons entitled to challenge a voter and includes only a voter who is a member of the political party for whose candidate a person is offering to vote at a primary election may challenge the person on the ground of party affiliation. Finally, the Indiana Supreme Court, since the 1900s, has upheld the constitutionality of statutes and practices requiring an oath of party allegiance from a challenged voter, the case is Kelso versus Cook, and very recently, the Indiana Supreme Court has upheld the constitutionality of the right of a political party to determine its own membership. Overall, to claim any form of malice, or more specifically, intimidation or threat, has resulted from the attempted exercise of a statutorily authorized challenge, is itself a threat to the exercise of a power or duty authorized under Title III. If we really want to litigate the merits of voter intimidation here today, threatening someone or coercing them away from the exercise of a power or duty under Title III is itself voter intimidation. Ms. Flynn had the right as a poll judge to exercise the power or duty granted to her as such to issue this challenge. Indiana Code specifically allows and establishes a procedure for the challenge of a voter in a primary on the basis of party affiliation. Accusing Ms. Flynn or anyone else of intentional harm or intimidation simply for undertaking a statutorily authorized challenge, which exists for the purpose of upholding the spirit and integrity of a primary election held amongst members of a political party, could itself more easily constitute a crime than undertaking a lawful challenge. And prohibiting the issuance of a statutorily allowable challenge is certainly contrary to the duties of any precinct election officer or a member of a county election board who is statutorily required to administer election laws. In closing, I would just like to acknowledge once again how emotional these matters can become. Issuing a challenge, being challenged, both actions may be uncomfortable. However, as I stated at the outset of my comments, we are not here to talk about emotions. The facts are as follows. It's the duty of this board to uphold Indiana's election laws. Indiana's election laws rightfully allow for the challenge of a primary voter on the basis of party affiliation. There is no requirement to justify that challenge because the constitutionality is upheld because that person is still allowed to vote. In fact, they don't even have to vote on a provisional ballot. They simply complete the affidavit and they vote in the election. There's no restriction on a person's right to vote in filling out that affidavit. A challenge was attempted but was not complete in this situation. Mr. DeHart's vote was cast and counted, and in fact, he did not even complete the PRE6 form, which itself could be questioned. Whether Ms. Flynn had the right to issue that challenge and whether Mr. DeHart had the right to vote without completing the form are not the matters in question here today, particularly given that the time has passed for resolution in either of those matters. The issuance of a lawful challenge is not intimidation. For the board to determine that there has been a violation of Indiana's election laws under these circumstances would be a determination based in emotion, not in fact or law. Given the foregoing, I respectfully request that the board determine that there has been no violation of Indiana election law. If the board feels that some action is appropriate, directing the appropriate authorities to focus training efforts ahead of next election on the proper issuance of and conduct related to a challenge is appropriate, productive, and will have positive impacts on future elections, rather than wasting time and taxpayer dollars seeking to litigate a matter for which there is no legal basis, and more than that, absolutely no possible productive outcome. Thank you, and I'm happy to answer any questions.
I do have a question.
Mm-hmm.
We had contacted both co-chairs at the Indiana Election Division. I contacted other parties, both Angie Nussmeyer, Brad King, Valerie Waracha, and Matthew Kokovar, that to challenge someone, and it be a valid challenge, they have to be from the same precinct. Bradley DeHart and Sherry Flynn were not from the same precinct, so this made her challenge void and moot.
Okay, so in response to that, I'll say two things. First and foremost, the law actually addresses who can issue a challenge like this in two separate places. It has not been litigated by the court, and I actually believe it deserves some clarity, either in the legislative process or through the courts. There's two different instances that address that. One says that a voter in a precinct is eligible to issue this challenge. We don't know what a voter in a precinct means. That could mean a registered voter who has the right to be in a precinct.
Mm-hmm.
Ms. Flynn is a registered voter who is credentialed to be in that precinct. It could mean a voter registered to vote in that precinct. We don't know because the courts haven't decided. The other part, which I cited in my statement there, states that a member of the same political party has the right to issue the challenge. So those two statutes conflict. I'm not a judge. I am not at all. I don't want to be. But I hope someday a judge will clarify that for us. It's not clear right now. What is clear, though, is that there's no actual harm that resulted from that question to take up here today. Mr. DeHart voted. His vote was cast and counted. Right. He did not complete the form. If there were a situation where he had completed the form, I think that would become the question, because then he could, believe that there was some harm to him in having completed that affidavit, and it would make more sense to litigate that issue. But because he didn't, I don't think it's worth diving into the merits of that, especially when we don't have clarity on the meaning.
And we have mentioned to them that the law is not clear,
Mhm.
but since they are the ones who are
Sure.
to interpret that, this is what we had to go on that, her challenge.
Sure.
Now, I wanted to ask, have you had a chance to read the article in the Indiana Capitol Chronicle?
Yes, I skimmed it briefly.
All right. Would you know if those statements and all are factual?
I don't know. I can't speak to that directly because I wasn't there. I would assume that statements made are factual, but I can't speak to that necessarily.
Okay, so then you would not be able to, I had the question, and we have so emphasized again and again and again and again and again, if there's a question, call the courthouse, call the courthouse. Every worker is given the phone numbers.
Mhm.
If there was an issue, why did she not call?
Yeah, I can't answer that question. That's something that she would have to answer. All I can say is that, again, attempting our very best as human beings to leave emotion aside. I'm sure there was some level of frustration on both sides because Ms. Flynn knew that she had, the authority to issue a challenge. Mr. DeHart was uncomfortable and unclear about the merits of the challenge. So there's, confusion at both sides. But at the end of the day, if the question here that you are determining as is your right to do so, whether or not there was a violation of the voter intimidation statute, I simply can't agree that exercising a statutorily allowable challenge for a statutorily allowable reason is voter intimidation.
Okay, do you have any questions for her?
Well, what do I have here? Well, my question is, when was the forms brought to Sherry?
I don't know the answer to that, but I'm also not sure it's relevant. Any poll worker should have access to these forms at any time.
Well, yeah, we wondered who brought them in, where she got them, and how did they get them to her in the voting poll?
Again, my response to that would be every poll worker should have access to the forms at any time because these challenges are statutorily authorized.
And they were in the totes.
Yeah, they were in the totes.
Yeah,
But she had her own.
I'm not sure why it's relevant because she'd be authorized to issue them either way.
She is allowed to have them.
Yeah.
But I think Mary Kay's question stems from the fact that she made mention that the chairman, after voting and all had started, that the chairman provided her with the forms. And it was kind of the question, how could he have done that? So that was.
I will say the forms are publicly available. Anyone
Right.
can go print them off. And so, some people actually get really into the process, bring their own stuff. I don't know. I will say, I know, and I did watch the video of the last hearing, so I got to hear some of the discussion. And again, these are emotional topics. I don't blame anyone at all.
Mhm.
You guys are doing your best. Everyone's doing their best. But there's questions about, whether, she had in mind that there were going to be Democrats voting in a Republican primary. That's actually the point of this challenge. The point of the existence of this challenge and the statute itself allowing these challenges is to reiterate that the point of a primary election is for an election to take place amongst the members of one political party. It does not prohibit somebody from switching political parties, from voting from one year to another in different primaries, fully allowed to do that. All that challenge form and the associated affidavit does is say, I am voting in this primary because I want to vote in a primary for the Republican Party, and I'm signing my name to that statement. Because what that does, and I'm not going to get too technical down the road here, is that, so say for instance, and it's not an accusation, but it does happen, if someone did want to vote in the other party's primaries, happens on both sides, because they wanted to get a weaker candidate elected for the general election or something like that. I have no idea. It happens all the time. In signing that affidavit, they're still allowed to vote. They're still allowed to cast their vote. It's not a provisional even, it's a full vote. But if they were then to run for office in the other party, let's say, then they could be challenged by that party. So it's upholding the integrity of both parties, actually, because then you have a basis on which to say, hey, wait a second, you just told us that you were a Republican, and that's why you're voting in the Republican primary. Now you're running for office as a Democrat. Does the Democrat Party want that? You know, and then it's up to them if they want to challenge on that basis. All this does is create a record, doesn't take away anyone's rights, nothing like that. And that's why the constitutionality of these challenges has been upheld by the court for so long.
Well, but he had no voting record in Indiana.
Yep, it doesn't, you don't have to have a voting record. It can simply be on the basis of a belief. I heard the guy at the bar talking about being a Democrat the other night, and so I'm going to give him this challenge because at the end of the day, the challenge does not stop someone from voting. So you're not taking away their rights at all. That's the crux of this issue here. You are not taking away someone's right to vote in issuing this challenge, and that's why it doesn't require justification. It does not harm them to fill out that affidavit if what they are doing is truly participating in the primary for the party that they want to be a part of, because then they're just proclaiming that. That's it. Again, that's why the Supreme Court has upheld the constitutionality of this type of challenge.
There's a whole lot of this that the legislatures and that need to clarify.
100% agree with you. And if anyone wants to join me in Indy to lobby on this, like, let's get a group. Let's do it.
Put it in a vernacular that people can understand.
Absolutely.
And make your
There's a huge
Laws
opportunity for clarification here across the board, and I actually think and appreciate the participation of everyone here because hopefully it can draw some attention to that issue.
Okay. All right. Okay. Thank you.
Yeah,
very much.
absolutely. Thank you.
All right. I did see the inspector come in. Okay. You do not want to testify? Okay. He doesn't want to be on camera.
Okay.
So and I will say many people, they are intimidated by cameras. Number one, guilty.
Two.
But that's the way it goes. Okay, I believe Mary Hackle, she was a judge. We'd like to call for her now. If you would like to step up here, please. All right. You could please give a statement, just let us know what you heard, what you saw that day, what happened from your perspective.
Okay. During the primary election on May the 7th, 2024, at the Tell City Depot, Precinct 1, 2, and 3, Bradley DeHart came in to vote in Precinct 1. Bradley DeHart requested a Republican ballot and was then challenged by Republican Judge Sherry Flynn. She said he had to sign a form saying he was selecting a Republican ballot. Bradley did not understand what was going on and refused to sign the form. Sherry made a statement to Bradley that if he failed to sign the form, all votes would be canceled that day. This went on for 30 to 45 minutes. Finally, Ben, the Republican inspector, told me to go ahead and let Bradley vote. Sherry then asked me who let Bradley vote, and I told her Ben said, and I, at that point, let Bradley vote. Sherry told me if Bradley voted, she was calling Channel 14 News and an attorney. So.
Okay. All right. So what do you think was Sherry's attitude toward Brad as she was telling him these things?
She was really upset.
Okay. All right. She speak calmly, or was she yelling at what?
She was yelling.
Okay. Anything else for that day?
Well, there's other people in it. What I think is kind of bad is there was other people in there trying to vote, and it doesn't look good for us for that.
Okay. All right. Thank you very much.
Okay, thank you.
Thank you, Mary.
Okay, thank you.
All right. Marcia Parker. Did I say that right? I'm notorious with Marcia. that name's pronounced so many different ways. Okay, could you please tell us just what did you see, hear, what went on from your perspective that day? And she was a clerk at the polling station
Yes.
that day.
I just heard her challenge Mr. DeHart. She was quite adamant about it. He said he did not understand what the reason was. She said that he had to sign this paper, that otherwise he couldn't vote. She was in his face. She was intimidating. And when she made the remark for Chris to leave the room, he said, "I'm not leaving," you know. From my perspective, if I would have been in that situation, I would not have wanted my spouse to leave the room.
Right.
She was intimidating. She was in his face. She said, "I will call the news office. I will call the TV station, Channel 14. I'm calling Indianapolis. I know what I'm doing." You know, and this went on for a long time. It was not just a 5 or 10 minute uproar. It went on for 30 or 45 minutes. And she was adamant that he was going to sign it regardless. And he was not comfortable doing that. He did not make any remarks except to say, "I'm not signing it." He was not in her face. He didn't approach her. She approached him. So.
Now, you said she told him that she would call the news and a lawyer and Indianapolis
Yes.
if he didn't?
If he didn't, yeah, she says, "I know what I'm about, and I'll call these people." And at one time, she left the room for a minute and came back. Now, whether she called anybody or not, I don't know. But she was determined that she was going to call somebody and that he was not going to vote. That's the way I took it. And in the meantime, people were coming in to vote, which, like Mary said, did not bode well for the community and for the atmosphere. And I would, in my opinion, the inspector should have taken over. Once she challenged that vote and he said no, I would have thought it would have been up to the inspector to make that call, you know, and to say, "This is what you need to do," or to de-escalate the situation a little bit.
Okay. All right, thank you very much. Okay, one thing that Bradley DeHart did mention in his complaint was he requested a ban on Sherry Flynn. And I will say that we will not take any action because we have no jurisdiction to act on this matter. At this time, I'm going to ask for a rebuttal from Ally Bartlett, given what we have heard already. If you have something to say.
Thank you so much. And again, thanks to everyone who presented and has taken part in this. I know it's not easy for anyone. At the outset, you read the definitions of the terms that constitute the definition of voter intimidation. I invite you to revisit them. Issuing a challenge that is specifically allowable under state law for a purpose that is specifically allowable under state law, whether we like it or not, does not meet these definitions. I heard, there were some questions about Ms. Flynn's attitude that day, whether she knew or didn't know that Mr. DeHart was a Democrat. It's been stated repeatedly that Mr. DeHart did not understand the challenge. Again, rightly or wrongly, and hopefully some progress can be made on these things. There is no requirement under the law to explain the challenge. There is no requirement under the law to justify the challenge. There is no requirement under the law to state how or why you assume that this person is of the opposite political party. Maybe, again, we can all take this up with our legislators in Indianapolis and get some clarity moving forward. Unfortunately, for these purposes here today, that is the law. The law does not require it. So to decide that there has been a violation of the law when there has been no violation of the law would not be correct. So I would just reiterate my request that the board determine that there has been no violation of the election law. And again, I'd like to propose a productive outcome, which I think could be directing the appropriate authorities to focus training ahead of the next election on the proper issuance of and conduct related to challenges. I think that's an appropriate outcome. I think it's productive for everyone and will have positive impacts on future elections, which I think would be a great legacy for you all as the election board. I would hate to see time and taxpayer dollars wasted on continuing this matter because there is no legal basis and no productive outcome. At the end of the day, I'd also invite everyone to keep in mind Mr. DeHart cast his vote. His vote has been counted. The election is over. He did not complete the affidavit. So with that, I am also still happy to answer any questions.
Don't think we have a question. Thank you very much. Okay. Then I would ask, based on the testimonies, does each member of the Perry County Election Board believe a violation of IC 314.321.5 occurred? Mary Kay?
Yes, I do.
Rachel?
Sorry.
It's okay. You're taking notes.
I know. I do, and I really appreciate what Ally has to say today. And I would like to use her in further when we have situations that come up to this and arise. I think some of the stuff she says, yeah, I absolutely agree with, but I still feel the way he was treated, it could have been done in a completely different way. And then based off those definitions, I do feel it was absolutely violated.
Okay. And thank you, Ally, for your presentation. When I gave the definitions, the one for defining the word threatening is to state one's intention to take hostile action against someone in retribution for something done or not done. The fact that she threatened to call a newspaper, call the lawyer, call Indianapolis, if it was me, I would take those as threats. So I would have to say, yes, I think there was a violation because she was threatening to do this, take this type of action against him. So I would have to say yes also. So I will make a motion to refer the matter and all documents to be submitted to the Attorney General or appropriate prosecuting attorney for any further action according to IC 36531. And all in favor say aye.
Aye.
Now, before we conclude this meeting, I do want to say something in behalf of the entire Perry County Election Board. We would like for it to be known that this situation is about the attitude and conduct of one individual to another. This is not a case of one political party against another. This is two individuals. And given the comments, accusations, and remarks made that I've heard that's gone through the county, we do not condone nor approve of any type of harassment or nasty comments made either toward Sherry Flynn or Bradley DeHart. This is something that will be passed on, and the legal authorities will determine if it's valid or not. We submit it to them. We are just looking at it from our standpoint, but we do not. There is no excuse to harass, belittle, put down, condemn people involved, and we do want to make that clear. So this will conclude our hearing for today. Is there a motion to adjourn?
I'll make a motion.
All right, seconded?
I will.
All right, all in favor say aye.
Aye. Amen.
Amen.
You may be dismissed. Thank you.